Hey there, Legal Tea listeners. This is your host, Jenny Roselle. Today's episode of Legal Tea is a cautionary tale where we talk about real-life cases, real-life clients. They are things me or my office have actually worked on. So for today's episode, we're going to be talking about a case, a client, where it's honestly a perfect example of two things. First, it's an example of not waiting until the absolute 11th hour to do your estate plan. And second, it's an example of what me as an estate and elder law attorney, someone like me has to weigh and analyze if someone has the mental capacity to sign estate planning documents. Unfortunately for us, there's no super pretty bright line rule. Something like, if someone has dementia, they cannot sign an estate plan. That doesn't exist, and that's not even necessarily true. They could have moments where they are lucid and could sign. So that's what I mean. There's really no bright line rule here. Now, there are laws and guidelines for us, but it's super, super vague, very subjective. So let's talk about what happened first and then get into the, when is it too late to sign documents, like after the story. Let's name the client Tom. So Tom's son and daughter-in-law reached out to my office and basically were pleading for help. Tom had no estate plan at all, and his health really started to massively and quickly decline. Every day, I'm not kidding, every day we got a phone call from Tom's son or daughter-in-law with something else that had happened to Tom and had gone wrong, to be honest. It was like a continual decline. At one point, we had talked to them about trying to get a trust in place so that we could seek Medicaid benefits for his very likely long-term care stay that really was kind of inevitable, really. Then things changed. Tom's condition worsened, and next thing we know, he's in the hospital. So we'd scheduled one of my attorneys in my office to go to the hospital to get some really basic documents signed, like last will and testament. Our thought was hey, if crap really hits the fan, at least we will have that in place. So that day comes, and our attorney gets to the hospital, and she finds out that the hospital actually had moved Tom, and the family didn't even know yet. That's how quickly things were moving and changing. And they had moved him because he had a massive internal bleed. So the attorney finally gets to the right room, and before she goes in, she asks the nurse about his condition. The nurse said that he probably really didn't know what was going on at all, and not to mention that he has absolutely no strength and probably wouldn't even be able to hold a pen to sign. Really sad, huh? So our attorney, in kind of an effort to confirm what the nurse had said, went into the room, attempted to talk to Tom, and discovered Tom was just flat not aware of what was going on at all. He did not understand who the attorney was, why she was there, etc. And like the nurse had said, Tom could barely even open his eyes. So the likelihood of holding a pen and signing was very unlikely. Actually, I would say completely unlikely. So the attorney stepped out of the room and actually gave me a call. And, in these kind of situations, it's always helpful just to bounce the situation off of another attorney just to make sure. And that's what she did. She was just making sure that, my brain sort of agreed with what her brain was telling her to do. And what she wanted to do was walk away and not let him sign the will. And I agreed. After she explained what the nurse said and what she had experienced, it was crystal clear to me that Tom was in no condition to sign those documents. So that attorney, she left the hospital and ended up informing Tom's son and daughter-in-law, and thankfully they understood our predicament. He just could not sign. And that's sort of where the story ends, at least for now. And I say it like that because this cautionary tale story actually just happened last week. So I'm not really sure if we'll hear that he's gotten better and maybe we can go back and try to sign, or if we will hear that he's declined again and he may pass away. Though I think the possibility of maybe signing in the future if he does get better is a really good transition to what I want to talk about as kind of the second part of this episode, as I referenced earlier, which is how does someone like me, an estate and elder law attorney, determine if someone has the mental capacity to sign estate planning documents like a will? And like I mentioned earlier, this is a really big gray area. I think a lot of people think that, if someone has been diagnosed with some sort of cognitive impairment, like dementia, for example, that they cannot sign. And that's not true. As many of us know, dementia comes in different stages. So think of someone who is maybe in the really early stage, and they usually have enough mental capacity to sign my kind of estate planning documents. So what is the standard to signing a document like a will, a last will and testament? I kind of feel like, when I started writing this episode, I was like, I kind of feel like I'm about to answer a bar exam question. But here we are. So the more you know, right? So for a will to be considered valid, the person creating the will must have two things: something called testamentary intent and testamentary capacity. And actually, I say that, but yes, it has to be those two things, but it also has like formality requirements too. Like a will has to have two unbiased witnesses. People think that wills require notarization, but not in Indiana, they don't. They minimally just need two unbiased witnesses, at least, like I said, in Indiana. Anyway, these two things, testamentary intent and testamentary capacity, are commonly shoved into kind of one big overarching requirement, but technically they are two very separate things. So first, testamentary intent means that you, the creator of the will, that you're of sound mind, who intends to make this will, and that you're free of any fraud and undue influence. And the latter thing basically means that there's no funny business going on, right? Like no one has a gun to your head to sign this thing. No one has pressured you into signing, etc. Now, second, testamentary capacity means that you as creator of the will, you have sufficient mental capacity. So what in the world does that mean, right? Well, let me tell you, the bar exam loves to test on this because it's such an old school rule. It even sounds really kind of old schoolish. So let me actually explain that. So to test if someone has sufficient mental capacity, you must first know the extent and value of your property. Second, know the persons who are the natural objects of your bounty. What? 3, you are capable of retaining the facts necessary to direct the making of a will. And 4th, you have to understand the nature of the act that you're about to do. So that's what the bar exam expects you to be able to spew out like I just did. But I'm sure you're thinking like, what the actual heck does all that mean, Jenny? So let's talk about it. In normal people language, it basically means that you, as like the creator of the will, have to know and generally understand not only just your assets, and we don't have to know to the penny, but we have to be able to say, like, generally speaking, some of your assets. Like, you have a house, that you don't live in like an apartment, that you have a checking account. You also have to know kind of the people around you, who they are and how they treat you. And you have to know that the purpose of the will is to take place after you pass away on those assets that you know of and to who you want them to go to. So I know that sounds like a lot, but it's actually a really low threshold. I actually, in sort of preparation for this episode, pulled my old bar exam outlines and notes. And they even say, that there's a general presumption that you as the creator of the will are totally fine and totally sane. So for someone to say you do not have the capacity to make the will, it's on them to prove it. And a little other fun fact in my outline, it actually says, do not be misled by someone that is eccentric. It's very difficult to win a lack of capacity argument absent concrete evidence. I just thought that was kind of funny. Like, don't we all get a little eccentric as we age? Okay, so if I anchor back to my story here, Tom, I don't think Tom had the intent or the capacity, right? He would have been effectively unable to overcome the hurdles, I think, to show he had the intent and capacity. He was more kind of like physical incapacity. He was worn down. He couldn't talk. He wouldn't be able to, he barely kept his eyes open, right? So he couldn't really voice his wishes and voice his goals. So how would we have even been able to tell if he had intent or capacity? And I think that's our answer. But compare Tom to someone who has dementia. So like I said earlier, it's possible that someone with an actual diagnosis of a cognitive impairment could overcome those hurdles, right? I've helped several clients who have been diagnosed with some type of mental incapacity, but they're in their early stages, and that they could very clearly express intent, and they could very clearly overcome that capacity test. Unfortunately, in my world, this is a very litigated subject, which I'm sure you could see why. It is so subjective, right? Is it, in my opinion, is the estate and elder law attorney okay for this person to sign? I'm not a medical doctor. I know the legal threshold of creating a will, and that's what I was just explaining. And, medical doctors would know the medical aspect, right? Obviously. So there are probably plenty of cases out there where the attorney thought it was okay to have the person sign a will, but that the doctors would say that the person struggles or maybe cannot even make legal and financial decisions. So those two things become directly in conflict with one another. Like I've talked about here on Legal Tea before, unfortunately, our legal system isn't exactly set up very well to handle like truly disputed cases. So often cases get settled because it becomes economically and financially inefficient to keep fighting. So parties end up settling. And, otherwise, if they don't settle, they could potentially get upside down. Meaning if they're fighting over, mom's estate that is worth $300,000, for example, and their legal fees continue to increase and accrue, at what point is it truly not worth it anymore? Maybe besides emotionally and to make a point? But you know what? That's why estate litigation attorneys exist, to navigate these waters. One way to deter disputes like this is really to encourage whoever is creating the will to document. And some attorneys have even developed a form for a doctor to complete that will specifically ask them questions, ask the doctor questions to gauge whether someone has that requisite legal capacity to sign. So instead of simply, asking the doctor hey, do they have capacity? Instead of that, they complete this form, which is making them answer questions to support or not the legal capacity test to determine if someone has that capacity to sign. And remember the things I was talking about earlier, do you generally know assets? Do you generally know the people around you, etc.? So instead of just asking the doctor, a more technical medical question, this form is kind of more fluffy. It's more fluffy questions about what does this person know? What do they understand, etc. Does that make sense? I actually had a client recently I think she's in her 80s, early 80s, that was disinheriting a child. And she was really concerned her child would say that she was off her rocker and when she made this change. So to deter that argument, she went to her doctor and had the doctor complete a similar form that I just discussed. So consider that idea. If you're concerned about someone kicking up a fuss, about capacity to sign a will. Alrighty, let's wrap this episode up and shift to a sneak peek of next week. We are back to the current events and current trends topic, and that's where we talk about something I've seen or run across that I think just would be interesting to talk about. Maybe I saw it on the news or social media or whatever. So during next week's episode, we're going to be talking about estate planning for young adults. And I was inspired to write this episode because I stumbled upon an article that really dove into this whole conversation about more and more and more young adults doing estate planning and why that may be. So we're going to talk about that and maybe talk about, what is a good estate plan for young adults. We'll talk about that next Tuesday, Legal Tea listeners. So until then, take care and be well, my friends.